Welcome to Plan on It.
Hello, everyone. Welcome back to Plan on It with Attorney Christopher Botti, board-certified specialist in estate planning, trust, and probate law. Chris has more than 30 years of experience helping individuals and families plan for long-term care and protect what they've built. I'm Sean O'Connor, and today Chris and I are talking about the Medi-Cal Lookback rule and how transferring assets at the wrong time can create serious problems when applying for long-term care coverage. Chris, good to see you.
Good to see you, Sean. Thank you for having me.
You bet. I'm not familiar with the look-back rule. What is it, and why is it so important when it comes to long-term care planning?
Well, yeah, in this look-back rule, there's a lot of misinformation out there on the internet because California's long-term care Medi-Cal program is completely different than any other state's long-term care program. They call it Medicaid in other states. And so there's a lot of misunderstanding about what this look-back rule is and how long it is. And we're going to get into the weeds on this a little bit because we have to take a deep dive on this because it's so important. So the look-back rule basically refers to California is going to look back a period of time to determine if any transfers were made in contemplation of a Medi-Cal application being filed. And so people try to transfer assets, reduce their worth in order to qualify for Medi-Cal. And there's a correct way to do it and an incorrect way to do it. And if you get the look-back rules impacted and they trigger, then you've got problems.
I got it. And so you mentioned what's the period of time? When does the look back period apply, and how far back are they looking, at the financial activity?
Okay, that's in California, it's very simple. It's 30 months. Okay.
Oh, I thought you were going to say 30 years. I'm like, oh,
no, it's 30 months. Okay. Most states, it's a 5-year look back. We get this all the time. What about the 5-year look back rule? Well, we don't have a 5-year look back rule in California. We've never had it. We're different. Okay. And I tell people, like, we're a good state to get sick in because our rules are different and much more flexible when it comes to qualifying people for Medi-Cal. So we have a 30-month look back. That's it.
Okay. And the people right now are doing the math. 30 months. Okay. That's 2 years. That's like 2.5 years.
Correct.
Yeah. So why even does Medi-Cal have a look back rule in the first place? Is it about fraud?
What the state would prefer is people use your own resources before you seek assistance, right? That makes sense from a public policy perspective.
Sure.
That, let's not give Medi-Cal to multimillionaires. Okay. So we have these rules where you have an asset test. And so what people sometimes mistakenly do is they'll start transferring assets improperly in order to qualify and pass the asset test. And if you do that, then you create problems for yourself. So the look back rule is designed so that people will utilize their own resources first, get to a level where the state says, okay, now that you're at this level, we will issue a Medi-Cal card to you and your family because you need to start, we want to provide these services to someone with your net worth, your wealth. Mm-hmm. And so the look back rule exists so people who try to make these transfers to get below and pass the asset test are penalized essentially for doing that.
So the when they're looking back, when they're reviewing the transfers, are there specific types of transfers that they're looking for?
Absolutely. So in Medi-Cal, we have basically two types of assets. We have exempt assets and non-exempt assets. Okay. Exempt assets don't count towards eligibility. And so, for example, your primary residence, okay, doesn't count towards eligibility. And so they're not looking at transfers of exempt assets. You can transfer exempt assets and not trigger any look back rules whatsoever. So it's the non-exempt assets, the other stuff that the state says, look, we're going to total the value of your non-exempt assets. And if that number exceeds the threshold requirement for passing the asset test, you're not going to be able to get a Medi-Cal card until you drop below that number. It's called your property reserve. Until your property reserve drops below the number required, you're expected to use your own resources to pay for your care. Mm-hmm. And so what the state's looking for is the improper transfer of non-exempt assets to others or third parties, and that's what they're doing. That's what they're trying to prevent. Mm-hmm. And that's what they're looking for.
Can you name a couple of examples of the non-exempt?
Sure, like cash assets, just regular cash in the bank account, CDs, brokerage accounts, not tax deferred. I'm talking about just a standard trading brokerage account, mutual funds, most annuities. These are all assets the state says, look, we're going to count these in terms of whether or not you're going to be deemed eligible for Medi-Cal. And if you have more than what we consider the property reserve, then you have to wait. Okay, that's essentially what happens there.
So what I would think of as being liquid assets for sure, right?
Correct. Definitely liquid assets, as the business assets can be potentially incorporated into the look-back rules depending on how that business is structured.
How does Medi-Cal determine the length of a penalty if a transfer falls within the look-back period?
It's a mathematical calculation, actually. So I'm going to give you an example of how we do it. Okay. So what the state basically says is, look, we're going to take the total value of the transfer. So let's say it's $100,000. And we're going to divide that number by what we call the average private pay rate of a skilled nursing facility in California, the average private monthly pay rate. And so that number adjusts every year for inflation. So the current average private pay rate is not a round number. It's $14,440. That's what the state says. This is the average cost of a 1-month stay in a nursing home in California. And so if you make a $100,000 transfer, you're going to take $14,440, divide it into $100,000, and that's going to result in a 6-month period of ineligibility where the state says, okay, you made a transfer improperly. You have to wait 6 months in order to come into us, and seek benefits. And so that's what they call a period of ineligibility. That's the penalty for violating the look-back rule if you do it incorrectly.
Got it. And so theoretically, that $100,000 that I moved improperly, they're basically saying you got to use that money to pay for pay for whatever services you think you need.
Right. The state's saying you should have used that money. Since you transferred it, we're going to penalize you 6 months,
right, essentially,
by dividing the average private pay rate into the total value of the amount transferred. And that's how they create this period of ineligibility.
Got it. Are there exceptions? Are there situations where, a transfer doesn't result in a penalty?
Well, yeah. I mean, if you do it for consideration, in other words, if you sell something for fair value, that's not going to be a problem because cash is coming back into the estate. But if you sell it for at a discount, then they're going to say, well, it's a partial penalty based upon the value of the transfer below fair market value. There are ways to make these transfers that don't trigger lookbacks, and that's covered in great length in my ebook about how we do it. California has a unique system that allows you to transfer assets as long as it's below the average private pay rate. That transfer will not count or trigger a violation of the look-back rules. So there's lots of things, the creative things that we do as elder law attorneys in this field where we can potentially get people qualified for Medi-Cal, taking advantage of the current rules as they exist and not violate the look-back rules. In fact, that's why you get an elder law attorney involved in the first place, is so you don't make these improper transfers, you don't create these periods of ineligibility, and you do it correctly. And if done correctly, you can get people qualified for Medi-Cal who have excess resources at the start of the process, but doing the transfers properly can result in qualification way faster.
It sounds like timing might be a factor, right? Is there a way that the timing of a transfer is going to trigger a penalty or maybe not?
Well, yeah. So the longer the landing strip, the better. And so if you're thinking, well, you're thinking for yourself or your spouse, it's very unlikely that we're going to need long-term care in the next 30 months, then you can make larger gifts because you're going to ride out that look-back period and realize that we're not going to need to tap into the program until after the look-back period expires. And so timing matters. But if you're trying to do this within 30 months of seeking a Medi-Cal card, in other words, applying for the program, you're going to have to deal with the look-back rules. So timing does matter. And then if you're in that period where you can't make transfers because you need it right away or you need it in a short run, you're going to have to plan around these look-back rules. And there are ways to do so. And that's really covered in great length in my ebook in terms of how we do it.
A little more than we can get into here. But, in your practice, I know you see a lot of mistakes. I mean, so many attorneys I talk, that's when people call, when they're like, whoops, what are some of the most common mistakes you've found people make when they're, when they're trying to move assets before applying to Medi-Cal?
Well, there's so many out there, and the state is not going to be advertising ways to avoid these mistakes. They would prefer, and I understand this, California, especially with our budget deficit, would prefer that you use your own resources. And so some of the mistakes that people make, they will actually make an improper transfer of a non-exempt asset in violation of the look-back rule. The good news is you can undo that. You can reverse that transfer and avoid that penalty. You just got to know how to do that, which typically requires someone like me to step in and help.
Got it.
The other mistake people make, it's a huge one, is with the knowing that exempt assets don't count towards eligibility. What people will sometimes do is they'll sell their home to convert it to cash, thinking they need to do so because it's counted as a resource. So now they're homeless, essentially. They're, and they're spending their resources down unnecessarily. That's probably the biggest, most fatal mistake that people make, is taking an exempt asset and liquidating it or selling it, thinking they need to do so because it counts towards eligibility. That's one of the reasons why I originally wrote the ebook, because so many people were making mistakes like that, that I said, look, I've got to educate my client base as they're getting older on the correct way to do this. And so that was the driver of me even putting that book together in the first place, because mistakes are being made left and right every day, because there's so much misinformation out there. There's so much noise in the marketplace that, you can't rely upon necessarily just doing a Google search or an AI search to get the true answer. And so you need to educate yourself, essentially. And so, you just don't want to make decisions that have really fundamental decisions about selling a piece of property, for example, without knowing, is that really necessary? And the answer is no, it's not, as far as your home is concerned.
Yeah, I mean, you may have some vacation house or something, right, that might be might fall outside of the exemption. But you were talking earlier about, okay, you made a transfer, you kind of violated a rule there, we can undo it.
Right.
Very hard to undo the sale of your home.
No, that ship has sailed, unfortunately. It's just tragic, actually. I mean, it really is tragic when people do that, or reverse mortgage your home, like take all the equity out, strip it of all the equity, when that was totally unnecessary. So again, I wish I can reach more people. That's the whole point of these podcasts. That's the whole point of the blog articles I do. That's the whole point of the ebook. I'm trying to educate people. Don't make these mistakes. They're devastating potentially.
Yeah.
It's just it's totally unfortunate when it happens.
Wow, yeah, that's crazy. So someone's concerned, right? They're concerned that, hey, I might need long-term care in the future. How early should they start planning so they can avoid these look-back issues? I mean, you mentioned the 30-month look-back rule, but are there, is it something like, oh, you should really do it, like you can't do it too soon, so to speak, or what's your best practice recommendation?
Well, again, the longer the landing strip, the better, in that you have more options, less duress, less stress associated with the need to get aggressive in the planning process. And so it all starts when you're doing your regular estate planning. We are much younger typically. You're doing your regular estate planning, and at that point, you want to make sure, I call this, make sure your estate plan is long-term care compliant. So in those foundational documents, your trust, if you have a trust, your powers of attorney, you're going to want to bake into those documents specific language to allow long-term planning, Medi-Cal planning to occur on your behalf. So it starts with the estate plan. Okay. Now, knowing that you hope not to deploy that language ever, but it's there in case you need it. And so that's the first thing you need to do, is when you're designing your estate plan, make sure it's long-term care compliant. Then as time goes on, if you're thinking, well, we got a diagnosis of early dementia, which we know that's a very typically slow and progressive disease, it will get to a point where you're going to need more help, potentially tap into the long-term care Medi-Cal program. With that kind of diagnosis, you want to start thinking about planning at that point, right? But sometimes you don't have the luxury of getting a diagnosis like that, where it's we call this immediate need situation or urgent situation, where there's a stroke or a crash or whatever, where like all of a sudden you're being discharged from a hospital into a skilled nursing facility for even if it's a short-term stay, and you have to scramble. And that we do that all the time, this immediate need or urgent care, urgent planning. It just creates more stress for the client, but they're very grateful that we have these options available to help. But in the perfect world, you do it further out. You wouldn't do it under duress, right? So we try to preach to our clients, be prepared, start thinking about these things as you get older, maybe when you turn 65. Okay, so should I be doing anything else? Reach out. For example, we encourage our clients to reach out to us and say, is there anything else we need to be doing at this point?
Mm-hmm. Well, that's great advice. Well, in this we're coming up on time here, but I'm wondering, for people listening, I know you do these Ask Chris Anything episodes, and so I want to share. This is such a can be a complex topic, and people may well have questions about it. If that's describes your situation, send your questions to info@bodylaw.com, and Chris, I'm sure in the future we'll be doing a Medi-Cal specific Q&A on that. So that's something to consider out there. That's it, Chris. Great to see you.
Great to see you. Thank you, Sean. And yeah, definitely, guys, if you want me to do a Medi-Cal specific Ask Me Anything podcast, just send the questions. I'm probably going to do one anyway, because there's so much to cover here. We're just, we took a deep dive today into Lookback rule, but ultimately there's so many other things we can talk about too. So we're going to be doing ongoing podcasts, definitely about Medi-Cal.
Excellent.
It's important.
Excellent. Well, that's it for today's episode of Plan on It with Attorney Christopher Botti. You can get more information, resources, including the 2026 Medi-Cal ebook that Chris has written, and information about upcoming estate planning workshops at the website bodylaw.com. Thanks for listening. I'm Sean O'Connor. And do us a favor, leave a thumbs up, leave a review, subscribe to the podcast, maybe share a link to someone in your world who you think would benefit from this Medi-Cal information. Have a great day.
If you're enjoying Plan on It, be sure to subscribe, leave us a 5-star review, and like the post. Share or tag friends and family who could benefit from clear, practical estate planning guidance.